If you run an erosion and sediment control contracting business in Queensland and you're facing insolvency, there's a survival instinct that can land you in very serious trouble. Today, I want to walk you through 4 key takeaways every ESC contractor needs to understand. First, experiencing a personal bankruptcy event generally triggers automatic categorization as an excluded individual under the Queensland Building and Construction Commission Act 1991. In practical terms, that may severely restrict your ability to hold a license or to manage an ESC company. Second, and this is where many contractors come unstuck, installing a spouse or a site supervisor as a nominee director while you continue to control the ESC business operations can expose you to criminal penalties for acting as a shadow director under Commonwealth law. The controlling mind almost always leaves a trail, and investigators know exactly where to look. Third, here's the misconception that catches people out. Placing your ESC contracting business into liquidation does not automatically extinguish historical environmental liabilities. The Department of the Environment, Tourism, Science and Innovation, DETSI, may pursue executive officers personally for sediment discharge events under Section 493 of the Environmental Protection Act 1994. In other words, the liability follows the director, not the company. And fourth, there is some good news. While an executive officer may face derivative environmental prosecution, a statutory defence may be available if the officer can demonstrate they took all reasonable steps to ensure corporate compliance. That's why preserving your site diaries, your correspondence and your maintenance records is so important. So before you make any move to wind up an entity or transfer plant and equipment, get proper advice early. The difference between a lawful restructure and a serious legal problem often comes down to a single conversation had early enough.